Hello, everyone, and welcome to Module 2. In this video, I'm going to be talking about negligence. I will provide an overview of negligence and the duty of care. In the previous video, wherein I provided an overview of torts, I had emphasized that a lot of the torts actions are actually based on negligence on the part of a particular defendant. And our focus in this particular video is to talk about what negligence means. And more importantly, we will talk about duty of care, which is one of the essential elements prior to anyone being able to claim that there is an action that could be founded on negligence. So as we will see later on, there are three key elements of a negligence action in tort. One is that there has to be a duty of care. Second, there will be a need to establish that there is a breach of that duty of care, which then leads to damage upon a particular plaintiff. We will see, however, that the issue of duty of care is a bit complex and is a bit vexing, mainly because when you think about the tort of negligence, even if it could be established that a person has been negligent, and it could also be established that as a result of a person's negligent action or omission, there has been harm suffered by a plaintiff. Those two elements, as we see, the presence of those two elements, as we will see, will not be sufficient to found an action on tort or the tort of negligence. It also has to be established that the defendant owed a duty of care to ensure that his or her actions do not lead to harm or injury upon the plaintiff. And so that's what we will be examining in this particular video. And in this video as well, I'm going to quickly just run through what we recall about torts as a form of civil obligation. So in this video, and at the end of this module, you should be able to identify the basic elements of a negligence action, discuss and explain the role and meaning of duty of care in the tort of negligence, explain the Australian approach for establishing duty of care, and have an understanding of the various control tests and limiting factors used by the courts, and apply your understanding of duty of care principles to fact scenarios. You should also notice that although we're talking of duty of care in this particular video, the issue of what the content of the duty of care is and what the standard of care might be are actually separate questions. And we will be discussing the concept of standard of care separately in module 3, or in the next video, but not in this one. So as I mentioned, it's one thing to talk about a duty of care, but it's altogether a different question as to what the content of that duty of care and to whom it might be owed, and in fact, what the standard of care might be that is part of that duty of care. We examine that in module 3. So again, as a reminder, what exactly is tort? In the High Court of Australia, in John Pfeiffer, Proprietary Limited versus Rogers, noted that the term tort is used to denote not merely civil wrongs known to the common law, but also acts or omissions which by statute are rendered wrongful in the sense that a civil action lies to recover damages occasioned thereby. So there can be a civil action on the basis of tort because an action or omission of an individual will often lead to harm or injury, and therefore the way by which society and the courts enable recovery for a plaintiff or suffered damage and injury will be in the form of damages. So which is why this is considered a civil wrong and not a criminal wrong that can then be punished by our criminal law. So it's a civil wrong. So the actions or omissions which lead to damage or injury are considered civil wrongs and not criminal wrongs, which are then punishable by our criminal laws. And because they are civil wrongs in the sense that they cause damage or injury or harm to an individual or to property, it will be it will then enable a plaintiff to seek to recover damages occasioned thereby. Again, when you talk about the key features of a tort, we recall there has to be an act or omission. And in this particular module, we're going to be examining that act or omission which can be considered to be negligent. And because of that act or omission which is considered negligent, that then leads to an infringement of a legally recognized right that causes harm or injury, and it will then lead to an action for damages. We also need to remember that as far as damages are concerned, which we examine in later weeks, that it is a requirement in an action for tort that there has to be a minimum amount of damage. In other words, as far as the Latin saying goes, de minimis non curat lex. The law does not concern itself in insignificant or minor matters. So in other words, if it's a minor or trivial thing in relation to damage, that will not allow for an action in tort, because otherwise the courts will be flooded by all sorts of litigation over very trivial matters. So an action for damages must involve a minimum amount in order for it to be allowed to proceed in the court system. Again, as a reminder, the legal basis for tort law would be common law in origin. In other words, tort law evolved mainly from decisions of the common law courts or of the courts. And to a great extent, tort law, especially in Australia, has been reformed by statute or acts of parliament. An example of this would be the Civil Liability Act of 2003, Queensland. There's also the Personal Injuries Proceedings Act 2002, Queensland. There's also the Civil Law Wrongs Act 2002, the ACT, and so on. So a lot of these statutes passed by the various state parliaments was an attempt at trying to modify the common law because of their rigidity and sometimes unreasonableness. And there was an attempt on the part of the various states to trying to arrive at a unified set of rules pertaining to tort law. That hasn't always been successful, as we see when we examine the various statutes of the various states. But again, the focus of our unit in tort law will actually be the Queensland Civil Liability Act of 2003. There will be some differences in terms of the provisions of the various state laws concerning civil liability acts or civil law wrongs. And yet our focus will be on the Civil Liability Act of 2003 Queensland, mainly because Central Queensland University obviously is based in Queensland. We will also recall when we viewed the Module 1 video that there are many kinds of torts. You can have a tort based on negligence. There could be a tort based on a breach of statutory duty. It could be based on nuisance, trespass to the person, trespass to land, intentional torts relating to goods, as well as defamation. A lot of these types of tort lead to physical injuries or physical harm. But as we know, there can also be economic loss. There can also be psychiatric harm or psychiatric injury as well. But a lot of what happens, as we know, when it comes to negligence, a negligence action, typically leads to physical injury. So for example, if a person has been very negligent in terms of driving his vehicle on the road, and that leads to an accident, that accident can in fact often lead to physical injuries, as well as mental injury or harm, when a plaintiff may end up suffering from psychiatric illness or depression and so on. Now, our focus, as I mentioned in this particular module, is to examine the tort of negligence and what it exactly is and what the elements of an action of tort on the basis of negligence must have. Again, when we look at common fact scenarios concerning negligence or negligent action, a lot of these, as I mentioned, happen in the context of car accidents. It could be slip and trips, like somebody is walking on a pavement. It could be in one of the shopping centers, and there might be a banana peel or It could be a grate there that somebody steps on, and that can lead a person to suffer injuries. And again, it raises that question of whether or not a plaintiff may be able to sue a particular defendant, especially if it happens, for example, in a grocery place such as Kohl's or Aldi or Woolies. A lot of the negligence actions are also based on work injuries. I recall, for example, I had a friend who suffered horrific injuries because in a manufacturing setting that he was in, one of the areas where they were stocking a lot of very heavy products collapsed, and when it did, it pinned him to the wall, which almost killed him. And a lot of these work injuries are actually quite common. It could be as simple as tradies being forced to be on a roof to try to, put the wooden structure of a house, or even put the roof, and in the process, they may end up slipping and falling. And that again the question that then arises would be whether or not there could be an action for tort on the basis of negligence on the part of an employer. There can also be negligence in the case of defective buildings or professionals who might provide, for lawyers, they provide wrong legal advice that leads to losses on the part of a plaintiff. It could be medical doctors providing the wrong medical advice, or surgeons, cutting off the wrong body organ. There might also be actions for negligence on the basis of psychiatric illness or even financial loss. So one of the most litigated areas of tort law is actually a result of negligence on the part of a defendant. We will also observe in this particular module that as far as the negligence action is concerned, its origin is in English law. And the main point about negligence action is that every person has a duty to take reasonable care not to cause harm to another person. As a general principle, of course, that becomes actually a very complex concept to examine when you think about who exactly is that other person that I must take care of to ensure that he or she does not suffer harm. Do I owe an obligation not to harm the entire world by my negligent action? And one of the key cases that we will come across when we study torts is a case of Liv versus Gold, where it was decided by the courts of the UK that a man is entitled to be as negligent as he pleases toward the whole world if he owes no duty to them. So that's so in other words, we can be as negligent as we like, but the question is, if by our negligent action we cause harm, does it mean that we are then liable on the basis of liable for tort on the basis of a negligent action? So think of a scenario like, you might have a pistol or a gun. Doesn't happen in Australia a lot, but if you left it in your house, and you probably left it in your bedroom, and as it happened, there was this burglar who came into your house. He played around with a gun, and then he shot himself. So let's assume that particular action, because you just left it maybe on your bedside drawer, that can be considered negligent, and it obviously caused harm to the burglar. The question then is, where can there be an action for negligence? Think about that. Or you might have a situation where you have a car, and as it happens, your car probably has some dangerous and combustible chemicals in it for whatever reason. You're probably thinking of doing a science experiment. And again, you might have a situation where somebody tries to steal the car, and when that person enters that car, it just causes an explosion. So it might be argued that there seems to be negligent action by you storing some harmful, some dangerous chemicals in your car, which obviously caused harm. But the question is, can an action for negligence then be made against you? And that leads to the question of a duty of tort, a duty of care, for there to be an action in tort. We also have to realize that carelessness or negligence is both recognized by the law as resulting from misfeasance or by an action, or nonfeasance or an omission. So it can be both an action or an omission. And the negligence action is always considered from the viewpoint of conduct and whether or not that conduct falls short of society standards, which means, therefore, that an assessment of conduct that falls short of society standards is always assessed from the viewpoint of a reasonable person. So there is an objective standard. It's not based on a standard of who the defendant might be, but on what a reasonable person might do under the circumstances to avoid a harm or injury to another, where there is a duty of care under those circumstances. Now, looking then at an action of the tort of negligence, there are three key elements that always need to be proven. As I mentioned, it is crucial that not only that there is damage or that there is harm, it is equally important, or is very important, in fact, to establish that there is a duty of care, and that as a result of actions, there is a breach of that duty of care that leads to damages. Again, because when we recall, one of the basic common law principles is that an individual can be as negligent as he or she likes. And even if that particular negligence can lead to harm or injury to another person, that will be insufficient to ground an action for the tort of negligence, because it has to be proven as well whether or not a particular defendant owed a duty of care to a particular plaintiff. And we need to remember, as we look at the cases, that these elements of duty of care, breach, and damage often overlap. Sometimes they can be quite interchangeable, in the sense that you can only examine breach of a duty of care by examining what the content is of a duty of care. So in other words, you cannot look at breach without knowing what the duty of care is, because every single particular action of the tort of negligence has to be examined under its own specific circumstances. You might have a set of facts that are similar, but the end result can be different, as I show in the next slide. One of the things we need to remember as well is that we recall that one of the crucial elements in the action for tort is that not only must there be damage, but it also has to be established that it was the actions, for example, the negligent actions or omissions of the defendant that were the cause of the damage. In other words, if the actions or omissions of a defendant, which led to damage that can be considered to be quite remote, then it is possible that the tort of negligence will fail. So, for example, if a driver, for example, has been negligent in driving on the road, and this leads to a vehicular accident which caused an individual, for example, to be transported by ambulance to a hospital, and let's assume that the main issue at the time it happened was that maybe a plaintiff suffered an injury on the left hand, but while assuming that particular plaintiff, while he or she was in the hospital, then suffered, was then infected by some kind of a deadly bacteria, which then led him to him being, to have his, to suffer, systemic organ failures, the kidney or the liver and so on, which then led to further amputation of the legs and amputation perhaps of an arm. The question is, would the driver then be responsible for the damage or harm that was suffered by the particular plaintiff. Or worse, what if the plaintiff then, in going home becomes depressed and becomes suicidal, and attempts tries to kill himself or herself? The question then is, would the plaintiff be responsible for all those succeeding injuries or harm that would then befall a particular plaintiff? And that goes to the issue of causation and remoteness, which we don't examine in this particular module, but something that I wanted to bring to your attention. We will also notice in this particular module that as far as elements of action of the tort of negligence is concerned, and in terms of the particular damage, it is often easier to apply the principles of duty of care in the tort of negligence in relation to physical injury rather than psychiatric injury or economic loss, mainly because of the potential indeterminacy upon the defendant. In the scenario I gave just now about the driver, causing injury to another driver, can you imagine the indeterminacy and the potential unlimited scope of liability if that particular defendant ended up becoming liable for all the damage that a particular plaintiff experiences? I'll also give an example later on of problems with economic loss, where one negligent action, would that mean that it triggers an unlimited set of liability on the part of a defendant? And that becomes problematic when it comes to the tort of negligence, as I show later on. Now, when it comes to the question of each of these elements, the question that often arises is whether or not the particular defendant owed a duty of care to the plaintiff. So that is the question that always arises. If there is harm or injury that is suffered by a plaintiff on the basis of negligent action or omission on the part of a defendant, the question is, did the defendant owe a duty of care to the plaintiff? Because if the defendant did not, then there will be an action for the tort of negligence will be unsuccessful. As I mentioned earlier, when it comes to an allegation of a breach of duty of care, you can never examine that particular question in the abstract, but you have to examine it in the context of the actual facts of the case. And as I will show in the next slide, you might have exactly the same facts leading to exactly the same kind of injury, but depending on the actual scenario, one action on the basis of the tort of negligence will fail, another one will succeed. Because negligent conduct, as we should always remember, is always considered in the context of a duty of care. If there is no duty of care, it is difficult to claim negligence on the part of the defendant. So let's examine the issue of duty of care, and when we do so, we will also have to consider the issue of reasonable foreseeability. So as I mentioned, on the one hand, what if you have negligent conduct and then there is damage upon a plaintiff? The question is, would the defendant have legal liability on the basis of tort for his or her negligent conduct or actions? Let's consider, and that question can only be answered from by examining the issue of, or the concept of duty of care. Let's look at the scenario. So assume that you have a house, and that house has a swimming pool. Okay, so you have a lot of houses in Australia which have swimming pools, and as we know, swimming pools can often be slippery. They can often lead to injury when somebody slips, on the pavement or on the surroundings around the swimming pool. Let's consider the scenario where you have a house with a pool and you have some uninvited teens, who come to your house because you were not there. They play around in the pool, and in the process, one of them injures himself. That teen might in fact become a quadriplegic, so become paralyzed in What does quadriplegic mean? So that's quad, four of the main bodily parts, I think. So let's assume that that scenario happens, but it happened to a teen who was not invited to the house. And in fact, in the scenario, we know that the teen, together with his friends, would have been an intruder. So if you consider the failure of the house owner to make sure that the swimming pool or the area around the pool is not slippery, then you might say that there seems to be negligent conduct. And obviously, it led to damage in the form of quadriplegia on the part of one of the uninvited teens. The question then is, would the house owner become liable for the tort of negligence? But I'll put it in a different scenario, exactly the same facts, but what then happens is that you have a teen who happens to be your next door neighbor. And while you were out, that teen went over your fence, played around near the pool, and same thing, same facts. He gets injured after slipping on the surface around the pool. The question is, would you as house owner be liable on the basis of the tort of negligence? So think about that closely, and think about it from the viewpoint of duty of care, and whether or not there can be an argument for reasonable foreseeability on the part of the owner that by his failure to ensure that the surface around his pool wasn't slippery, there was reasonable foreseeability that it could lead to harm or injury to an intruder as opposed to a next door neighbor. You might also have a situation where you might have infestation of some rats in your property. And what you do as a homeowner is to put rat poison in the kitchen. And again, in that particular scenario, what if you had a burglar, uninvited, who goes into the house and sees what he thinks is food, he eats it, and he suffers damage? Would you be liable for his injuries? A different scenario, it is a guest who goes to the house and thinking that it was food, he eats it. And again, the question of whether or not the homeowner would be held liable on the basis of the tort of negligence actually revolves around the issue of duty of care, and more particularly the issue of reasonable foreseeability that this particular set of persons or that these particular injuries might lead to harm. Okay, so think about those. Now, moving on. Historically, when it came to the tort of negligence, the only things that needed to be proven was that, one, the defendant had failed to take reasonable care, and as a result of the failure to take reasonable care, it caused plaintiff's injury. So if these two elements were there, bang, the defendant would be held liable for the tort of negligence. In a sense, though, as I mentioned, that can be quite problematic because, as I mentioned, you could have the scenario of the pool, slippery pool, causing injury to a burglar or uninvited teens, or rat poison causing injury to a burglar. And in that case, it opens a particular defendant to almost unlimited legal liability and indeterminacy as to who he can be liable to. And this particular scenario was examined in the case of Heaven versus Pender, which came out in the UK in 1883, decided in 1883 by the Queen's Bench, which involved a contract by which a ship was being painted. The plaintiff in this particular case was a painter who was actually hired by a contractor, and so that particular contractor contracted with the owner of the ship. And looking at it from the viewpoint of contract law, you will notice that because the painter was not hired by the owner of the ship, it could be argued that the ship, even if it caused injury as a result of negligence, the ship owner couldn't be held liable for the injuries of the particular painter because they had no privity of contract and there was no contract between them. And An argument could also be made by the ship owner that he did not invite the plaintiff to do the painting. If there was, a painting job that was to be done, it was upon the invitation of the contractor. So if there was liability, the liability of the ship owner could only happen if the contractor himself had suffered injury. But in this case, it was the plaintiff who was a painter who had no privity contract with the ship owner, who became injured when one of the ropes was cut loose by accident, and he fell and injured himself. The Queen's Bench made a ruling that in this particular case, although there was no contract between the painter and the ship owners could still be held liable for the injuries of the plaintiff on the basis of negligent action, the failure to ensure that the ropes would not snap, and therefore the painter would not fall and suffer injury, because there was negligent action on the part of the owner. But more importantly, the court ruled that the ship owner owed a duty of care, not just to the contractor, but to other people who were working with in the premises where the ship was being repainted. So this was the first time that there was an additional element that was added to the tort of negligence, so that it is insufficient that in order to ground an action for the tort of negligence, it is no longer sufficient to prove that the defendant had failed to take reasonable care, and on the basis of the failure to take reasonable care, the plaintiff suffered injuries. It was also therefore important to prove that there was a duty of care, and it was a breach of the duty of care that effectively led to the harm caused to the plaintiff. So that was the case of Haven versus Spender. In that particular case, the Queen's Bench ruled that whenever one person is by circumstances placed in such a position with regard to another, that everyone of ordinary sense would at once recognize that if he did not use ordinary skill and care in his own conduct with regard to those circumstances, he would cause danger of injury to the person or property of the other. A duty arises to use ordinary skill to avoid such danger. And so therefore, in this particular case, the Queen's Bench held that the duty of care arose because the plaintiff and the defendant were in the specific relationship of inviter and invitee. In other words, apparently, the plaintiff was there to do the repainting upon the invitation of the shipbuilder or the ship owner. And again, as we think about that case of Haven versus Spender, you have to consider what specific relationships, therefore, gave rise to a duty of care. So that's basically the question, one of the questions we need to arise. Under what circumstances or under what specific relationships would there be a duty of care? And here, there was a duty of care because there was an inviter and invitee. In other words, going back to that scenario, the swimming pool or the house where a burglar, for example, ate rat poison, the question is, was there a specific relationship of inviter and invitee? In the case of the uninvited teams, there was no specific relationship of inviter and invitee, and so therefore it could be argued there is no duty of care. The same thing with the burglar. However, in relation to the uninvited neighborhood teams, neighbors, teams who are your neighbors, and they come to your house, it could be argued that in two ways. One, they could have been previously invited, and therefore they assumed they could just come to your house. Or it could be that as far as the teens are concerned, if you have a swimming pool there, it becomes a temptation that is just too difficult to resist. And so therefore, that will be the basis for a relationship of inviter and invitee that will then ground a duty of care. The other way of looking at the case of the principle of duty of care is to examine the case of Donahue versus Stevenson, which is one of the more important cases in tort law, which we recall involved an instance of two friends going to an ale bar, and the friend purchased a ginger ale from the bar owner, and then he gave it to his friend. The friend drank the ginger ale. He found out that there was a dead snail in the ginger ale, and that caused him, physical and mental injuries. Or let's just focus on the mental injury there, because it led to vomiting and so on. The question was, could that friend who did not buy the ginger ale from the bartender or the bar owner, could he proceed against the bar owner given the absence of a privative contract between them, because the contract of sale was only in relation to the bar owner and the friend who then supplied, that plaintiff the ginger ale. And the court, the House of Lords in this particular case ruled that on the basis of tort, that friend to whom a ginger ale was supplied could proceed against the bar owner on the basis of tort, because the House of Lords said that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. So in this particular case, the House of Lords considered that the other friend to whom the ginger ale was given was a neighbor of the bar owner. And because of the actions of the bar owner in being negligent in supplying ginger ale that had a dead snail, then the bar owner could be held legally liable on the basis of the tort of negligence. And in that particular case, the House of Lords said, who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. So, but we will see that there is a problem with this concept of the duty of care arising in favor of a neighbor. Even the question of who is my neighbor, because that can be too broad. Who exactly is my neighbor in terms of legal contemplation, and particularly in terms of reasonable foreseeability? So part of the duty of care problem really is, where does the neighbor concept end? I'm going to give you some examples in a short while. And to how many cases can it be applied, and where exactly are the outer limits? So, when you think about a neighbor, is your neighbor the next door? I mean, in a very layman sense, when you think about the neighbor, who exactly is your neighbor? Especially in the era of social media and the internet. Is your neighbor, are neighbors those located very close to you? And of course, it just can't be that. So in other words, if you will have a duty of care in relation to your neighbors, can it be considered that everyone is your neighbor? And where does the neighbor concept end? And so these questions continue to test the senior common law courts of both Australia and the UK and elsewhere. Okay, where am I? Okay, let me jump in here. The question about the duty of care, I think it's in one of the other slides I have there. Consider a case where in the era of COVID-19, let's assume that there is a company which requires all its employees. It's less problematic. Well, it happened in Australia, however, but let's assume that there is a company that requires all of its employees to continue working, even if they appear to be sick. And let's assume that as a result, there appears to be a worker who has COVID-19 and is involved in sales. And this individual employed by this particular company then goes on a sales visit to a client, and in doing so ends up infecting, some of the employees of that particular client company. And because a lot of these, it doesn't have to be COVID-19, it could be some other viral infection. And as a result of the infection, a lot of the key personnel end up becoming sick. They miss their sales targets. They're unable to comply with their contractual obligations with their own customers, leading to multi-million-dollar losses. Okay, that scenario. The question then is, that particular company that had hired the sales employee, who then infected the employees of a client company, would that first company be liable for all the physical harm and all the economic losses suffered by the client company? So that becomes problematic when you look at it from the viewpoint of who the neighbor is, questions of proximity. Because surely there has to be a point where courts must be able to limit the number of potential claimants or the number of potential plaintiffs. There must be a point where a court would have to say, the losses can't go beyond this, or the time period during which those losses might arise. Because would it mean that because of the negligent action on the part of a particular defendant, that particular defendant can be held liable, as events unfold and as bad events cascade down the months and down the years? So that becomes a basic issue. And so therefore, for the court, when it examines the issue of duty of care, there's always that aspect of a control mechanism. The duty of care principle becomes a control mechanism because the more widely it is and more encompassing it is considered, so that every single defendant, upon a defendant is imposed a broad duty of care, that will mean that that particular defendant then will owe multiple obligations to various potential neighbors and various potential plaintiff litigants. And so the courts have a role in trying to control the flow of litigation in order to try to limit the floodgates of litigation, as well as in order to set limits to what is considered to be a high level of indeterminacy in terms of the defendant not knowing to whom he can owe certain duty of care obligations. So when we examine the duty of care, we will notice that the courts may continue to increase the categories or scope of liability beyond that which is traditionally recognized. Some of these categories we examine here in this particular module. And this is done so again within the context of the need for certainty, so that if there is an open-ended view as to what the level of duty of care might be, that will lead to indeterminacy and the possibility of unlimited and unbridled litigation. So in terms of summary, when we examine the duty of care, it is crucial that the liability in negligence is based on proving a duty of care to people in the position of the damaged party. So there has to be a duty of care. The duties, as we recall, are owed to certain classes of people. It is not to the whole world. So the plaintiff has to show that the defendant was under a duty to exercise reasonable care and skill because his or her conduct involved a foreseeable risk of injury or harm to the others, and the plaintiff was within the class of persons to whom that duty was owed. What typically happens in these scenarios is that where a plaintiff is injured, that plaintiff will often have to cite precedent in order to show that in this particular class of cases or individuals who suffered injury on the basis of negligent action, there is precedent to show that a duty of care was owed. Now, some of these well-known and established categories would include employer and employees. So there is a recognized in negligence actions, there is a recognized category of where duty of care is presumed to exist. And this, for example, is in relation to employers, employees, where the employer is expected to ensure that the proper plant and equipment are provided and maintained so that they do not cause injury to their employees. So if you have an employer who fails to properly ensure that the equipment there do not cause harm, it can be falling stacks of products, or it could be an equipment that fails and causes severe burns, then in that particular case, this is an established category and the employer will be held liable. There's also a requirement, an expectation that part of the duty of care of an employer is to ensure that there's a provision of a safe system of work, as well as the proper selection of skilled persons to manage and superintend the business. There's also a duty of care that is recognized in the case of medical professionals and the patients, in the case of motorists in relation to other road users, in relation to parents and third parties, to ensure that a parent has a duty to control children so that they do not cause injury to third persons or property. So they're at least in relation to parents of young children, because again, you might have scenarios where, like what's happening in Queensland in recent months, where there seem to be some rampaging teens who steal, teenagers who steal cars, expensive cars, and they just wreak havoc on the roads of Queensland. And the question then is, do these parents who fail to control their teens, can they be held liable for the injuries that may be suffered by third persons? And of course, more than asking that legal question, as we notice, is that if we examine a theory of tort law as being based on the issue of compensation, one of the problems we often see is that it will be pointless to pursue an action on the basis of the tort of negligence if you know that the potential defendant doesn't have any money. So in many cases, a lot of these teens who steal cars and then end up, killing people on the roads or damaging property, their parents don't really have the financial resources to pay damages. So that can be problematic. But what it does tell you is that if you are a parent and you have a young child, you go, perhaps in a shopping center, and the child knocks off an expensive item, you can be held liable. The case of McHale versus Watson. Another established category would be in relation to professionals and clients. It could be in relation to financial advisor providing financial advice to a client. It could be in relation to a lawyer providing legal advice to a client. So these are established categories where the courts recognize that in these particular scenarios, in these particular categories, a duty of care exists. Now, again, when you examine the issue of duty of care, one of the critical issues really is, was there reasonable foreseeability? Yes, it might be said that a duty of care exists, but could it be reasonably foreseen that under the circumstances, a defendant owed a duty of care to the plaintiff? So that's basically the question. So assuming that there might be a potential duty of care, the basic question that arises is, could it be argued that a defendant owed, could it be reasonably foreseen that a defendant owed a duty of care to the plaintiff? So that was it reasonably foreseeable to an ordinary person in the defendant's position that carelessness of the sort alleged might cause harm of the general type of complained of to a class of people like the plaintiff? So if you examine, for example, the case of Chapman versus Hearst, in this particular case, there had been a vehicular accident. It was Chapman who was responsible for the vehicular accident, and then as a result, there was a doctor who tried to come to Chapman's aid on the road. So Chapman, by his negligent action, suffered an injury or a road accident, and As a result, there was a doctor who saw what happened, and the doctor came to the rescue of Chapman. But as the doctor was trying to aid Chapman, who was responsible for the road accident, he was then killed by a second driver. In this particular case, there was no doubt that the second driver could be held guilty of, or could be held liable for the tort of negligence. But the second driver then sought to make as a co-defendant Chapman, who was responsible for the road accident, for the first road accident. So the question then is, did the injured first driver owe a duty of care to his rescuer? Okay, so think about that. Could the first driver who caused the road accident, which led to a rescuer being killed, could he be held responsible? The answer is yes. The High Court ruled that it is sufficient if it appears that injury to a class of persons of which he was one might reasonably have been foreseen as a consequence. So it was reasonably foreseeable, in other words, that if somebody is involved in an accident, it is reasonably foreseeable that there will be somebody who will come to his or her rescue. And as a result of coming to the rescue, especially in a situation where there are cars or on the road, that rescuer can be harmed. So there was a duty of care under those circumstances. The court also pointed out that reasonable foreseeability does not require reasonable foreseeability of the precise sequence of events which lead to injuries. It's sufficient that it can be reasonably foreseen that this kind of injury can potentially happen. Now, before we leave this particular case, again, we need to remember that under the common law, there is no general duty to rescue anyone. So as I mentioned, I think in the welcome video, even if you are a very good swimmer and you see a child struggling in the surf, and you know that the child is drowning, even if you are the only person there who can be in a position to rescue the child, you do not have a legal obligation to rescue the child, so that if the child in fact suffers injury or harm or dies in the process of you failing to rescue that child, you will not be held legally liable under common law. Okay, so when it comes therefore to the duty of care test, and as I mentioned, the test is about reasonable foreseeability. The key question is the sphere of reasonable foreseeability. So there has to be a limit, a scope of the sphere of reasonable foreseeability. There has to be a point at which it starts, and there has to be a point at which it ends. It can't be indeterminate, so that you become, you become potentially liable for everything. So the key question is, what class of people might possibly be put at some risk of injury in some way if the defendant failed in some way to take reasonable care? And is the plaintiff one of those people? So that's the basic question. So that makes a distinction between an intruder and somebody who has been invited to the house or invited to the car. Now, what we need to remember, however, is that even though the answer might be yes, that this particular plaintiff can fall within that class of persons to whom a duty of care might be owed, it does not necessarily mean that the defendant then owes the plaintiff a duty of care. It doesn't follow, because what we often will see in the cases is that the duty of care is always tied to the question of breach. You can't examine the issue of duty of care in the abstract. You have to examine the particular breach scenario. So that oftentimes you look at the breach in order for you to determine whether or not there is a duty of care in the first place. So instead of asking, is there a duty of care in this scenario? That becomes problematic, as the courts have seen, because if the answer is yes, it will often necessarily follow that the defendant will then become liable in the tort of negligence. So one way of looking at it is sometimes to examine whether or not, on the basis of the actions or omissions of a particular defendant, where there has been an allegation of breach, was there a duty of care? So in other words, because of the overlapping concepts of duty of care, breach, and damage, these three elements always have to be considered before you answer the question of whether or not there's legal liability on the basis of the tort of negligence. The other question that arises is, even if it is stated that a particular defendant owes a duty of care to a particular class of plaintiffs, it doesn't follow that a defendant should then have to take action to protect those people from harm. It doesn't follow. Again, that is because even though there is a duty of care, even if that is acknowledged and recognized, the nature and the content of duty and the extent of duty, these are separate issues. The issue of standard of care, these are separate issues. Yes, there is a duty of care, but the question is, what exactly is the nature of the duty of care? What exactly is the duty of care, and what is the extent of the duty of care? These are separate issues. A good case in point would be the case of Cole versus South Tweed Heads Rugby League Football Club. So in this particular scenario, you had a plaintiff who was drunk, as a result of drinking at the club. And South Tweed Heads Rugby League Football Club was aware that that particular drunk individual had been drinking there and could potentially suffer harm when that individual leaves. And that's in fact what happened. The drunk plaintiff left the club in an intoxicated state and was run over by a car outside the defendant's club. The question then was, should the defendant be held liable? What do you think? And the answer is no. Part of the reason why the defendant couldn't be held liable was that when you think about it, there is that policy issue, for example, of autonomy. Should the South Tweed Heads Rugby League, for example, really prevent a customer who's been drinking a lot from leaving the premises? Which leads to an operational question: what exactly would the bar do? Lock the doors or tie up the drunkard customer? So that's a problematic question. And if the company that serves the drinks, for example, severely limits the freedom of the customer to drink as much as he likes, wouldn't that lead to issues of autonomy? Shouldn't individuals, one, have the right to determine what to do with their own lives or their own free time? And two, shouldn't individuals be responsible for their own safety? So these are some of the questions that will end up having to be considered when it comes to issues of duty of care and reasonable foreseeability. So that, in essence, what it means is that the duty of care cannot be determined in the abstract. Okay, so when you ask the question of was the duty breached, it cannot be answered in the abstract, but you need to consider the particular scenarios and the facts. So as I mentioned, I've kind of highlighted some of the problems when it comes to the basis for the issue of reasonable foreseeability. We recall in the case of Donahue versus Stevenson that Lord Atkins talked about the duty that a defendant has to ensure that his neighbor does not suffer harm. But that leads to a question of who exactly is your neighbor. And one way of looking at it is the issue of proximity. So a neighbor is somebody who is proximate or near to you. So that the duty of care therefore consists of two issues: reasonable foreseeability and proximity. So in the case of Jansch versus Coffey, Justice Dean, for example, said, proximity involves the notion of nearness or closeness and embraces physical proximity in the sense of space and time between the person or property of the plaintiff and the person or property of the defendant, etc. Now, this legal principle of reasonable foreseeability being based on proximity, nearness, and closeness, both in terms of physical space um, and circumstantial proximity, for example. This was quite popular in the early 1980s and 1985 during the years when Chief Justice Mason led the High Court, but it was ultimately abandoned for being too imprecise. In the case of Miller versus Miller, the High Court ruled that when you talk about the issue of proximity, it really doesn't state nor point to any relevant principle that assists in the resolution of disputed questions about the existence of a duty of care. So what typically happened, the court observed, was that when a defendant was held liable, there was first a finding that he was held liable, and the liability was based on the fact that he seemed to have been proximate to or very near or close to the plaintiff. But there was really no underlying, principle behind it. So it was more of a finding of breach under the circumstances that led to a showing that they were proximate. But why they were proximate couldn't really be answered, because when you look at other factual scenarios, you might have situations where a plaintiff and defendant could be under the same circumstances of being proximate, but there potentially could be no finding of negligence. There was a bit of a change in the case of Ans, versus London Borough of Merton, because here we will notice that the court was clear that there sometimes has to be a policy question involved. So in the case of Ans versus London Borough of Merton, there was a claim on the part of the plaintiffs that this particular local council had the responsibility to examine the structure and any potential structural defects of a building. And because of their failure to properly examine the structural defects, harm had been caused to the plaintiffs. But in this particular case, the House of Lords ruled that the existence of a duty of care, more than going to the issue of proximity, it depended on a two-stage test. One, was the harm reasonably foreseeable? But two, if it was, were there any policy grounds on which the law should negate or limit the scope of the duty? This is a crucial point because if you will recall, I think in the first video, the welcome video to the unit, I had mentioned that my son, who's now 19, suffered a big gash on his left foot, which was almost severe, when he stepped on glass, on the rocks, as he was trying to jump off a rock formation in a quarry in Caboolture. Okay, now you might have a situation where a local council is responsible, owns a quarry or owns particular lands and so on. But the question is, what if a property that is owned by a land council is a site in which a plaintiff suffers injury? We can argue that the harm is reasonably foreseeable, but the question then will be, should the council then be held liable for the harm? And as we see in a lot of the cases, I think in week 3, when it comes to the standard of care, policy grounds can often prevent an action on the basis of the tort of negligence against a local council, because the courts would say that if you allow a tortious action to be taken against a local council for all sorts of potentially negligent action, there is no limit to potential council liability. And the only way for the local council to ensure that no harm would befall certain individuals would be to plug these gaps. But in doing so, where would the funding come from? So that when you examine the case of Ans versus London Borough of Merton, the court was saying that you would oftentimes have to consider policy grounds on which the law should negate or limit the scope of the duty. And that, of course, is an acknowledgement of the importance of judicial policy, which we recall I highlighted previously the issue of potential judicial activism, where it is the courts that kind of reshape tort law, as opposed to the parliament, the state parliaments, for example, that determine what tort law ought to be, mainly because it is the state parliaments that, under a framework, constitutional framework of government, are actually the branch of government that creates law. Now, this approach, in the case of Annes versus London Borough of Merton, was initially accepted by the Australian courts, but again, that approach is not without its critics, mainly because, again, is there really a place for courts to get involved with matters of policy? Shouldn't that be matters of policy be left to the executive, or should be left to Parliament? And secondly, when it comes to policy, for example, it no longer involves a legal question that might involve political, social, and economic questions, which really are not within the scope of the duty of a court. So there has been criticism of that as well. I also mentioned earlier that as far as the duty of care test, it is unsuited to economic laws. I gave the example of the COVID infection or bacterial infection. One of the issues as well would be the case cited in our prescribed textbook of a ship that negligently spills chemicals in the rivers, for example, and as a result, what if the government then passes restrictions in relation to the economic activities in the area because of the chemical spill, which can be harmful to human life. And because of the government restrictions, a lot of businesses fold or they close. And what if you have a business that closes, and as a result of that business closing, there's another business that is affected? And further down the line, the question is, should that ship be held liable for all of these cascading losses? And surely there has to be a point where issues of indeterminacy come into play, and the courts will have to say, no, there has got to be a point where the negligent action of a defendant should not lead to that defendant being liable for all losses in an unlimited way, especially when it comes to economic loss. Personal loss or personal injuries, for example, are kind of discrete and circumscribed because, when there is physical harm that is suffered by a plaintiff, surely there's a limit in terms of losses of limb and losses in terms of capacity to earn. But economic losses, that's in terms of business losses, for example, that's almost unlimited. So what it means is that the search for a duty of care test actually continues. A lot of different judges have used different methods. In the case of Caparo, the approach was to have a 3-stage test of reasonable foreseeability, closeness of relationship, meaning proximity, but then the question of whether it would be fair, just, and reasonable to impose this particular duty of care upon the defendant under the circumstances. Again, that question being that you cannot divorce duty of care without looking at the actual factual scenario. The example being that local council, can you imagine if would it be fair and just and reasonable to impose upon a local council a legal obligation or a duty of care to ensure that no harm befalls any member of the community in all the lands and properties that it owns? And it will be easy to argue that it will not be fair, just, and reasonable, because otherwise the local council will have its hands tied and its budget tied in trying to avoid that these losses do not eventuate. There's also an incremental approach, and the reasoning analogically from decided cases and edging the law forward in small steps, so that the attempt is to try to examine if that under this particular case facts, so whether or not, given that there are certain recognized classes of cases or persons where there is a duty of care, can it be said that it can also apply by analogy to this particular scenario, to this particular plaintiff? So that is an incremental approach. Reasonable foreseeability continues, however, to be a strong guiding principle, which returns to the simple neighbor principle and focusing on the word reasonable as the limiting factor on foreseeability. So when you examine, therefore, the issue of reasonable foreseeability, what exactly do we mean by reasonable, and what can we consider to be reasonable in terms of a duty of care? There's also been the salient features approach, and what the courts do in the salient features approach is to identify the salient features that matter, the features which are glaring, the features which can really be highlighted. And part of the salient features that can be considered would be the plaintiff's autonomy and the ability of the plaintiff to take care of himself, make decisions for himself, and take care of himself to make sure that he or she doesn't suffer injury, as well as the vulnerability of the plaintiff. But that leads to questions: what exactly are the features that should be considered salient? Now, as we have seen, therefore, although we know that there are three elements in an action for tort, you need to establish that there was a duty of care owed by a defendant, and you need to establish that the defendant breached that duty of care, and as a result of the breach of duty of care that led to injury or harm to a plaintiff. We then ask the question of what exactly, under what circumstances exactly, does the duty of care arise? And we canvass that issue about the issue of proximity, the neighbor principle under the case of Donahue versus Stevenson. We looked at Ann's versus Merton. We looked at the Caparo principle. We looked at the incremental approach. We looked at the salient features approach. We looked at the reasonable foreseeability approach, focusing on what exactly is reasonable under the circumstances, which makes us say that negligence cases can be quite difficult to litigate then, and it can in fact be quite difficult for the plaintiffs to establish success or try to be successful in an action for tort. Although that might appear to be the case, that's not really true, because in most of the negligence cases, they're actually less complex and controversial, because it's easy to show whether or not there is in fact a duty of care, given the established classes or cases of duty of care that is recognized under tort law. So that's not really problematic. So even though we try to canvass the approaches towards issues of duty of care, in truth and in fact, many of the negligence cases are less complex and controversial. Most cases are in fact straightforward. There is a duty to take care because reasonable foreseeability is enough to give rise to a duty of care in such cases. And so at the end of this module, you should be able to identify the basic elements of a negligence action, discuss and explain the role and meaning of duty of care in the tort of negligence, explain the Australian approach for establishing duty of care, and have an understanding of the various control tests and limiting factors used by the courts, and apply your understanding of duty of care principles to fact scenarios. And so with that, I thank you for watching this video, and I hope to see you in our tutorial. Bye.